look at it or kind of review it. Actually try to write out answers to all the questions. This will be a much more valuable session if you do these things. Now you ask Josh, why is there only one question? I thought your exams were 2 questions. Yeah, they are. Spring 2020 was a weird year. That was the COVID semester. And you may not know this, but we decided to go to a pass-fail grading scheme, which I think was a disaster for a lot of reasons. It made sense at the time. I opposed it to the bitter end, but I was the minority on that one. But an entire semester of students had no evaluations, had no grades. It screwed up employment prospects. It didn't give students a chance to know where they were. Students who were struggling had no feedback. And I'll tell you, there were a number of students who did the pass-fail option who flunked out after the 3rd semester, who really should have made it to the 2nd semester. It really hurts the students at the bottom of the class, didn't help them at all. But we were living in uncharted water, so we had pass-fail. People don't like to talk about the consequences, but here we are a year later. So I gave a shorter exam that year. I didn't give a full exam for a lot of reasons, so that's why there's 1 question, but your actual final will have 2 questions. Any questions on the schedule going forward? Yes, Grayson, go ahead.
Just for the 2020 spring exam, was it supposed to take the same amount of time that a normal exam would have taken?
I'll tell you the truth. What happened, Grayson? We were giving an exam online for the first time. Students were panicking, so I told them, I'll tell you what, take 3 hours for what should be a 90-minute exam. You should take 90 minutes. You don't take 3 hours for that exam. Just take 90 minutes. Oh, you took 3 hours?
Yeah.
Okay, well, I guess that's my fault. All right, well, that's fine. Take 90 minutes for the future if you haven't taken already. But yeah, it was an unusual circumstance in which students were so upset and panicked that I said, instead of giving the normal exam, I'll give you 3 hours for the half, right? So basically half an exam. That way no one can complain that, oh, I had distractions at home, this and that, right? I tried to eliminate everything. And because it was pass-fail, it didn't matter, right? It was truly one of the worst exams I've ever graded in my life with pass-fail. I could not believe how poor the students were prepared. People just phoned it in.
There's definitely time left over, so
yeah. I appreciate that, Grace. Thank you for the clarification. But you should try to do it in 90 minutes, not 3 hours, because that would be the more accurate one. Quinny, what is that? You're waving? Yeah. Yeah, hold on. Yeah.
I have a question, but I don't want you to miss me.
Yeah, go ahead.
So if we did already do the parks exam, when we had questions or wanted to go over it, should we just wait till Wednesday, or should we?
Well, what I said was, if you had done it already, so if you've done it by today, email me right now.
Okay.
And I will be happy to set up a time to meet with you beforehand. That was the cutoff I gave. I said class on Wednesday. If you do it now, I'm not going to get mad. But if you haven't done it yet, that's fine. You can do it over the weekend or do it on Monday morning, whenever. But we'll go over as a class on Wednesday. But just for the one-on-ones, I feel bad, but I can't do one-on-one review sessions for 90 students again. It's just, I can't. There are not hours left in the semester. So that's why I had sort of an arbitrary cutoff date. I've done that in the past, and just each of those sessions takes 20, 30 minutes, and there are not hours in a day. So I have to be, respectful of all my students. But a bunch of you have emailed me, which I'll be happy to set times with you. Okay. What else? One other note, if any of you are looking for employment over the summer and possibly the fall, I am looking for a research assistant. For summer for sure, possibly fall, and if it works out well, even for spring. Very often I have it for all 3 semesters. The commitment is 5 to 10 hours a week on average. The school approves up to 20 hours. I doubt I will have many 20-hour weeks. It might happen every now and then. But be love just help me with research stuff, blue booking, citations. If you have a good attention to those sorts of details, apply. If you don't like those things, probably not the right job for you, which is fine. It's not for everyone. But blue booking is a plus. So if you send me your resume, your transcript, and your writing sample in the next 2 weeks or so before the semester finishes, that will be helpful. I don't need an official transcript. The unofficial one is just fine. So if you can get to me in the next 7 to 10 days before the semester runs out, that would be helpful. That way, if it's a good match, I can get the paperwork process going, because the federal work study pays, but there's paperwork you have to fill out. You have to do stuff, and it takes weeks. And I want someone who's basically ready to go once finals begin. I'm sorry, once finals conclude. I won't make you work during finals, but when they're over, I'll have stuff for you. Because my current RAs are about to go on finals break, so I have to get ready for the next crop. But it's enjoyable. Is Natalie your RA? Yeah, I think Natalie's done work for me. You can ask her. I think I'm good to work with. Not your RA, but your Langdell. I'm good to work with. It's enjoyable, but there'll be work. All right. Anything else? Anything else? No? Okay. Alrighty then, let's try a poll question to get ourselves thinking. All right, and this one's multiple choice. This one's going to be tricky. My other section had difficulty with this one. I think this one, well, maybe you won't. Who knows? Maybe you'll surprise me. But my other section divided this one sharply. So question number 1. Landlord gives tenant a 1-year lease for an apartment. The rent is $1,000 a month. The fair rental value of the apartment is $1,200 a month. The tenant asks the landlord if he can exit the lease 1 month early. That is, after the 11th month concludes. The landlord says nothing. The landlord spends $100 on an advertisement for the apartment, and the day after the tenant moves out, the landlord rents the apartment to S for $800 a month. How much does the tenant owe the landlord? $0, $200, $400, $500, or $1,000? All right. Ooh, this one's split. Got a nice distribution on this one. All right. Who's next up on my list? You'll never hear me say this again after this class. Who's next on the list? This is just, this list goes away. God willing, next year. Usually what I do in person is I go up and down the rows. That makes my life a lot easier. I don't have to do the stupid alphabetical stuff. Who's up next?
I think I'm up.
Who's that, Michael?
Michael Davis, yes.
Okay, Michael. So, Michael, let's start off one step at a time, right? What kind of lease do we have here?
This is a term of years lease.
Okay, how do you know that?
Because the first sentence says L gives T a 1-year lease for an apartment.
Good. Is this periodic?
No.
Okay, very good. All right, so Dave, not Dave, I know your name. Michael, the follow-up question, with a term of year lease, is it possible for the landlord to get out of it? I'm sorry, is it possible for the tenant to get out of it early by giving notice?
I believe it is possible, yes.
Okay, how much notice has to be given?
I think typically it's 1 month's notice.
Okay, that's not correct. But that's not correct. Emma, you here?
Yes, I'm here.
With a term of years lease, Emma, is it possible for the tenant to get it early?
No.
No, why not?
You have to wait until the term of the lease is up.
It's fixed, right?
Yeah.
So in this case, in this hypothetical I gave you, is there any legal effect that the tenant gave 1 month advance notice?
No.
It's irrelevant, right?
No.
Now, Michael said you have to give usually 1 month notice. What kind of lease does 1 month notice work for?
That'd be a periodic.
Excellent. Like a month to month, right?
Yeah.
Okay, very good. Thanks, Emma. Right. So this is a good exam style question because I can sort of put several topics together, right? When you're dealing with leases, your first step should always be to identify what kind of lease do you have here, right? Is this a term of years? Or is this a periodic tenancy? If the tenancy is periodic, then notice is relevant. If the lease is a term of years, notice becomes irrelevant. This lease is going to end when it's going to end. At the 1 year mark, it's over, not a minute before, not a minute after. It won't renew, right? Doesn't go month to month unless the parties agree otherwise. It's over. So the fact is, this lease ends after 1 year. And what that means is the tenant is responsible for the 1 year rent no matter what. All right. Michael, go ahead.
Just curious so it says landlord says nothing. If the landlord said, "Oh yeah, that's okay, you can get out of your contract earlier," then would that excuse?
I think oral. So why am I hesitating to answer your question, Jack? Why might oral consent may not be enough? Think about it for a second. Let's say you have a written lease, and then the landlord says, "Oh yeah, you can leave early." Is that enough? Statute of frauds. What might you need to get out of the lease full, legit?
Written.
I think so. Yeah, I think that's right. I think even if the landlord said, "Oh yeah, sure, that's fine, you can get out," that would not be enough to obviate the lease. I think you'd actually need a written statement, which effectively supersedes the lease, right? If the landlord and the tenant agree, you have a new agreement, and that's fine. But I think you'd have to have it in writing. I don't think an oral disclaimer can nullify a written lease.
So I don't mean to be difficult, but so technically you could get out of.
If it's an oral lease, so you for a lease of less than 1 year, it doesn't have to be in writing. So if you had an oral 1 year lease, then I think you could have an oral termination of 1 year lease. But if you have a written 1 year lease, I don't think you can terminate it with oral consent.
Okay, thank you.
Yeah, if you notice this last week of contracts, this last week of property feels like contracts. We're talking about duty to mitigate and unjust, right? These are all contracts concepts, but they come into play here. Okay, thanks, Mike. All right, that was Emma. Okay, so Lacey, let's go on. Okay, so we have a term of years lease. Tenant vacates 1 month. Lacey, here?
I'm here.
Okay, right. So you have a one term of year lease. The tenant vacates a month early, and we learn that they spend $100 in advertising, and then they rent the apartment out for $800 a month. Okay. The landlord sues the tenant. How much does the tenant owe?
Well, and my initial response would be the difference between the $800 plus his $1,000 rent, plus the $100 that the landlord spent on advertising.
Which is how much?
Which would be $300.
Which is not a choice.
Right.
And actually, it's funny. I realized I should have made 300 a choice because someone else said the same thing in the other class. I was like, damn it.
Right.
So I hate multiple choice questions. So tell me again, how'd you come up with 300?
Well, because the difference between the $800 that the landlord actually got, plus is the $1,000 that he should have gotten if the tenant hadn't vacated, plus the $100 that he spent on advertising. So it would be $300. But I thought, well, it must be the fair market value then, which would be $400 plus the 100, which would be $500.
Excellent. Okay, so the answer here is 500. That's D. Which, all right, actually about 45% we got this one right, which is not quite half, but close to half, which is I think better than the other sections. So kudos to you guys. All right, Lacey, walk us through one more time. How do you get to 500? Which might be your first answer, but your final answer.
Okay, so the original, the fair market value of the apartment is $1,200. But when the tenant vacated, the landlord could only get $800 in rent. So there's a $400 difference between the fair market value and the actual rent he's receiving.
Good.
But then he spent $100 on an advertisement to lease the apartment. So I added that in as well.
Okay, really good. Excellent. Thank you so much. She's exactly right. So a rule of thumb for you generally to think about, if I give you the fair market value in a question, you probably need to use that number. Right? I'm not just giving you just for funsies, right? It probably factors into your answer somehow. And think about it this way, right? He had a 1-year lease for $1,000 a month, right? And then maybe they signed this lease when the market was a little bit slower, right? Prices weren't as high. But over the course of the 1 year, maybe the market picked up. When the landlord moved out early, I'm sorry, I keep saying the landlord, I'm sorry. When the tenant moved out early, it put the landlord in a pinch. Right? The landlord was in a pinch. He had guaranteed rent that just vanished. And so he scrambled. He rented out the apartment to the first person he found and only got $800. Had he had more time to plan, right, he could have taken maybe more time and gotten a full $1,200, which is what the market value would cover. The tenant is on the hook not only for what he would have owed, but what the landlord could have gotten, plus the landlord's costs, right? So some of the other questions have been, Josh, why isn't it 1,000, right? Why isn't the full amount? That would be an unjust enrichment, right? If the landlord is getting 800, he can't charge the tenant for that 800. You can't double bill. You can't double dip, right? So what you have to basically do is take the market value and subtract the rent that's being paid, which is 800. So 12 minus 8 is 4. And then there's a fixed cost of marketing, which is 100. So 400 plus 100 is 500. The answer is D. But this question is tricky because it involves a lot of different concepts, right? And there's some sort of dead ends. If you get hung up on the fact that there's notice, you know, oh, well, there's notice, the amount owed is 0, right? A couple of you put 0, right? Because you probably thought, oh, he gave notice, so there's nothing due. That's not right. A couple of you put 1,000. You think, oh, the full amount? No. You can't have unjust enrichment. The next most common answer was B, which is $200, which maybe you were thinking the difference between 800 and 1,000. Makes sense, but you have to go to the fair market value. So I'm just looking at how you guys distributed it, and I can explain how each one I think got where they got. Okay, Jeanette, go ahead.
Hello. Is there any argument here for us to apply like the rules of surrender or not, because we're talking about a term of years? Term of years,
yeah. It does. I'm sorry.
That's what I was thinking.
Yeah. I mean, are you thinking of like the case with the leaky basement case we have next?
Yeah, something like that.
But there was no breach though. The surrender rule only works if there's some condition or circumstance that makes you surrender. Here, they just stop paying rent. Right. There was no eviction, constructive or actual. So I don't think that sort of doctrine would really make sense here. Make sense? Grayson, was your hand up? It went up and down.
Yeah, I just kind of want to know if there was an argument for even the for not using the fair market value and using the actual $1,000 that the tenant owed. Is there like or is it just a fair right line rule that you're going to use the fair market value?
Well, generally they're the same, right? Often the actual rent and the fair market value are the same. But in case where there's a disparity, you can go with the fair market value. Let me flip it. What happens if the fair market value is $1,200 and he managed to get a $1,500 a month rent above market value? In that case, the landlord or the tenant owes 0, right? Because the landlord will be fully compensated for his loss.
Right, which startles me a little bit because he was gonna get that $1,500.
Right.
That was it.
Right. So it basically like the fair market value cuts both ways. If you get a below market rate, then the tenant has to pay. If you get an above market rate, then the tenant goes scot-free.
Right, which doesn't seem as just as the other one. I know it's just one man's opinion, but
That's fair.
Kind of, yeah.
That's fair. Okay, Lacey, I see your hand was up.
Yeah, I was same with Grayson. I was just wondering like what the reasoning was for basing it off of the fair market value versus the actual rent that was due. Because I mean, contracts is my worst subject and I hate it, but it just seems like as far as expectation interest or whatever, like $1,000 should have been.
Yeah, no, I know it's a little bit unsettling, but the idea is since the person moved out, in theory they could have gotten an even greater rent, but they were under the gun, right? Short in time. It's almost like an expectation damage type calculation. One of my students made that point in the other class. Alyssa, go ahead.
So I actually was thinking along the same lines as Grayson and Lacey, remembering from contracts. There was something that we learned that said that the actual cover price is a ceiling on the fair market value. And I'm not quite sure if that applies only to goods, but that's just what I remembered, that when you have the actual cover price, you can't get over that if the fair market value is over that. So I'm wondering how that applies here.
I don't think that rule governs here. I haven't seen that, so I'm not sure, but that doesn't sound like something I've seen in property cases. So in other words, I mean, this topic embraces contract law in large part, but it's not, one-to-one. It's not 100%.
Okay.
So it's possible. I don't remember seeing that before.
Okay. All right. Thanks.
Not my pleasure. All right.
Can I ask a question too? Sorry.
Who is that? I can't see who that is.
Taylor.
Taylor. Okay, go ahead, Taylor.
What happens if they don't cover or substitute the landlord? Are they is the tenant on the hook for $1,300?
All of it. Yeah. So let's say the landlord in this question was not able to find a tenant and the entire month passed without any rent being paid. At that point, the landlord could sue for the full amount, $1,200 plus $100. Yeah. Right. So in other words, had the landlord just stuck it out, he would have had to pay $1,000 for the last month of his lease. But by leaving and putting the tenant in that landlord in that awkward spot, he's paid even more. Yeah. Which is why leaving rent is always risky. Okay. Questions on that one? Yeah, Grayson, go ahead. I see your hands up.
But if it went the other way, could he possibly get to pay less for his breach?
Well, pay less or pay zero. I'm not sure what you mean.
Like we just said,
the landlord won't owe the tenant money. That's not going to happen. I mean,
no, I understand. I'm saying like you just said, like if the tenant didn't stick out the lease, he would owe the fair market value.
No, if he just stayed in the lease and didn't vacate, he only owed $1,000. Right?
I meant vacate.
So if he did vacate or did not vacate?
Did vacate.
Once he vacated, he's in breach and he's on the hook for even more damages.
Right, but what if the fair market value is less than that 1,000? Could he still use that instead of the 1,000, even though he breached?
Oh, I see what you're saying. Right. So let's say the market went to hell, right, and the prices dropped in the neighborhood. It's like, okay, go ahead, go rent that for $500 a month. Yeah, I suppose in that case he could be on the hook for even less than he would otherwise. So yeah, so I suppose in a declining neighborhood you can actually game it to get out of your last month rent. I suppose it's not a very smart thing to do, but you could do it.
Yeah,
I wouldn't recommend it. All right, that's good. I guess that question took a bit, but I thought it was a good question. All right. Any other thoughts on this first poll? Okay, then the topic for today is security deposits. All right, that's our first topic. I suspect everyone in this room has paid a security deposit at some point in their life. Yes. Yeah, I've paid several. I mean, now I own a home, which is nice, no more security deposits, but I paid many. I think I told you I had a dog who peed and pooped no matter what I did and ruined every carpet of every apartment I've ever lived in. So I paid. My security deposit was never enough. No matter what I paid, I always owed more at the end. Always, no matter what happened, it just magically I always owed more because the carpet had to be replaced just every freaking time. I hated it because I would just pay for someone else to have a brand new carpet. That was my toll of moving. But the idea of the security deposit is basically a insurance policy for the landlord, right? When the landlord lets you into their apartment, they don't know what's going to happen. Maybe you're going to disappear, right? Maybe you won't pay rent. Maybe you'll cause destruction or you'll damage property. The purpose of the deposit is to prevent those things from happening. Okay. Generally, a security deposit is calculated based on a person's risk factors. What does that mean? If they have better credit history, if they have a history of renting apartments, the deposit's less. One of the last leases I signed was actually in a medical center, and my deposit was $0. I couldn't believe it. Yeah, you don't know anything. You're good, Josh. I pay other fees for the freaking dog, but the security deposit was $0. I shouldn't say freaking dog. She was a good dog. She passed away, but she was a good dog. But her bowels were never settled. It was just you get used to it after a while. And now I have kids pooping on the floor, so just we're in a different world. It's true. It's true. Their mom's on the phone laughing, right? When they run off the potty, that's what happens, right? It's true. It happens. You'll see one day. But the landlord gives the security deposit to try to prevent risk. Generally, the deposit is limited to 2 months of rent. Right? That is the ceiling. We'll get to in a minute attempts to go more than that, but that's usually the limit. Sometimes it's 1 month rent, sometimes it's 2 months rent, but deposit can be significant, and that's something the landlord hold on to. This next part's important. The landlord cannot put the security deposit money in his bank account. The landlord must create a special trust account for each tenant. What's a trust account? It's a segregated, separated account, which the landlord cannot use for expenses. The money must sit there for the entire duration of the lease. And that account can only be tapped when the lease is over or there's a breach. Right? So let's say the tenant randomly disappears. The landlord could use that security deposit to pay off any unpaid rent or to cover damage costs. But that money must be kept separate. Something which you may not know and which most people never even see is this trust account must generate interest. The trust account must generate interest. Now, I've never once gotten interest in my deposit. Anyone? No, this is like the biggest scam in the world, but it's supposed to generate interest, right? Why? This is not money for the benefit of the landlord, right? The landlord's not supposed to profit on it. The landlord can't invest it, put it in the stock market, because that's available in the event of a breach. This will be a familiar concept to those who work in law firms. You've all heard the idea of a retainer, right? A retainer. What's a retainer? If you want to hire a lawyer, you generally give them a sum of money up front called a retainer to retain the lawyer's services. And as the lawyer bills hours, they just withdraw from the retainer, right? When you give that money to the retainer for the lawyer, it's not put into the lawyer's bank account. Each client has a separate a separate trust account, right? A separate trust account. That money cannot be mixed or commingled with the lawyer's accounts. It must be kept separate, right? The lawyer can only withdraw from John Doe's trust account to pay for John Doe's legal fees. The lawyer cannot withdraw from John Doe's to pay for Jane Roe's expenses, right? They can't, pay the power bill, the electric bill, or the gas bill from someone else's trust account. You don't believe me? The easiest way to get disbarred, the easiest way to lose your law license is to screw up client funds. Why? Because it's so easy to prove, right? Most legal ethics questions are very blurry, right? Was there a conflict of interest? Well, that's hard to prove. Did you breach some duty of care? That's really hard to prove. Did you fail to advocate? Did you fail to make a certain argument? That's really hard to prove, right? But you know what's easy to prove? You screwed up by taking money out of your account, right? There was $1,000 in the account, and then there were $900 in the account. We know where that money went. It went to you, and it did not go to your client's expenses. When you are attorneys, you'll get a bar journal in the mail, or virtually every month, right? And if you flip to the very back, there's a section on disciplinary actions. And every month, I promise you, there's going to be at least one person in your state bar, maybe even from this law school, who got disbarred or sanctioned or suspended for mismanaging client funds. One of the easiest ways to lose your license is to screw up client funds. I always make this point here because I want to drill this into your heads. Resist the temptation. And here's how it usually happens, right? There's all this money sitting in a client trust fund, and the lawyers have billed you. It's like, okay, you know what? I'll take out a little bit now, and I'll put it back in when I get paid next month. No. That doesn't work, right? You can't dip in and put it back in. That's money for the client. That's not yours. And if you do that and the client finds out, which they always do, they always find out. Clients don't understand everything a lawyer does, but they know what billing. That they know. They know what a billing statement looks like. And if they say, wait a minute, why was my balance $1,000 and it was $900 and it's $1,000 again, right? So that's how you get screwed. You get yourself in trouble. And you work so hard for a license and you just blow it. I remember years ago there was one of these ethics questions in one of the newspapers, and the idea was a hotel mini bar, right? And the question was this: at a hotel mini bar they'll charge like $10 for a little box of Oreo cookies, right? So what if you eat the box of Oreo cookies there, then you go to CVS and you buy the exact same box of Oreo cookies and you replace in the mini bar? Is that unethical? And I think it is, right? But it's the same idea, right? It's, well, you're just taking money and you're replacing it later, right? No, it's not yours to take. It's the mini bars, right? It's not how the cookie was supposed to be crumbled, so to speak. Anyway, so take it for whatever you want. No, I do not. If you take it from the mini bar, don't replace it with something else, because actually most hotels now, they actually have sensors on the devices. So if you take it off the device, it adds it to your tab automatically. In most hotels, they have basically this RFID. So if you remove it from the base, it just bills you, so you can't even cheat anymore. Grayson, is that cookies?
No. Can that money in the trust not be touched by anyone or just the lawyer? Because I understand some people don't like the idea of sitting money.
Well, look, if the client wants to withdraw from the trust fund at any point, they can, but that might sever the retainer, in which case the lawyer doesn't provide services. Right. So if the attorney says, if the client says, give me back my money, the attorney says, fine, we're severing the relationship. At that point, I think the attorney can bill for whatever service has been rendered, but he has to give that money back. Right? Because imagine, let's say the client says, I want to go to another attorney. I don't like you anymore. You can't force what to say with you. That's unethical. So you would have to, at that point, take out whatever costs you have, give what's called an accounting, which is basically a listing of here all my itemized reductions, and then give the check to the client. Say, okay, go find another lawyer. I'm not your lawyer anymore. Right. So again, you can withdraw the money, but then you lose your lawyer, which is always risky to do in the middle of a case. I mean, I make this point. People don't like it, but it's true. What's the most important rule of lawyering? It's not Rule 11. It's not 12b-6. It's not Rule 7. It's get paid, right? If you don't get paid, you don't have a livelihood. You can't keep the lights on. You can't, pay for food on your table. If you're a government lawyer, your paycheck comes from the taxpayer, so that's, I guess, kind of easy. But for everyone else, they have to collect, right? Retainers are nice because there's no collection. They pay up front. But for other attorneys who don't get paid up front, they have to collect. They have collection agencies. They have to make phone calls. It's not pleasant. If you're dealing with criminal, right? If a person randomly gets arrested, they have to raise money for defense. They don't have money. They have to put the car up for sale, right? Put a second mortgage on their house, right? These are issues you have to deal with. And after defending a client and you lose the case, he still has to pay you. And you maybe have to put a collection agency on him. Not pleasant to think about, but it's part of the business. Especially if you're at a smaller firm. Bigger firms have other people do this, but at smaller firms, the attorneys have to do their own collections sometimes. I once had an attorney I knew. He lived in Florida. He did collection work. I think I mentioned this. He was very aggressive. He said he once put a lien, or he threatened to put a lien on someone's dog. And he said, if you don't pay this bill, I'm going to lien on your dog. It's a chattel. I'm going to seize it. He didn't actually do it because it scared the crap out of the debtor. But it's a chattel. You can put a lien on anything, right? You basically repo the dog. Yeah, that's what you learned last day of proper last repo. I'm imagining your notes. Blackman said repo dog, right? You're laughing, but it's true. You can repo a boat, a car, or a pet. I mean, come on. In divorce cases, dogs are a huge issue. It's a chattel. It's marital property. And you can't slice a dog in half, so one of them has to get it. And it's often a very heavily litigated asset, as you would say. All right, any questions? I'm having fun last day of the class. All right. All right, so let's go on then to the actual case for today. What happens when the landlord breaches? Right, the landlord breaches. There are two general reactions. One is that the tenant decides, you know what, landlord, you screwed up. I'm going to reduce the rent I'm paying. I'm just not going to pay as much money. The second one's more dramatic. It's, I'm not going to pay the rent, and I'm getting the hell out of here. I'm leaving. I am terminating the lease unilaterally. Those two moves are tricky, right? Because in both cases, a court may say you were wrong. There was no breach. The duty to pay rent remained, and you're on the hook for the rent, even though you weren't there. Okay. So let's do Sandra. Sandra, you here? No, Sandra. Victor, you here?
Yes.
All right, Victor, let's go ahead and do our Village Commons case from Marion County. It's in Indianapolis. Let's. What were the facts here?
Okay. So essentially the Marion County Prosecutor's Office, who's the defendant in this case, leased the basement of a building from Village Commons. And Repo, who was the landlord and the plaintiffs, for an office and essential storage space for evidence. So it was a 7-year lease that began in August 1999. And during that time, there were water leaks. I believe there was a total of 14 leaks. Oh
God, you actually counted. Good for you.
Yeah. I was just kind of interested because I made a list of them. So they started in 2001, ended around 2003. During that time, that created mold, fungal growth, which is obviously toxic. Yeah. Some employees got sick, and I believe 78 boxes of evidence were destroyed or damaged. So essentially, the prosecutor moves out, and then the tenant sued for breach, but waited a while without taking steps to mitigate damages. And they talk about the exclusive remedy provision, which essentially states that the tenant cannot terminate the lease or hold rent on their own. But the court discusses how constructive eviction and actual eviction may allow that. So that essentially when the prosecutor vacates, he leaves 4 years early and about $400,000 of unpaid rent.
Okay, excellent. Okay, thank you so much. Very, very good, Victor. All right, so there's a lot going on in this case. We have a prosecutor's office that signs a 7-year lease for this basement apartment. Okay. things, I guess, are going okay for the first year and a half or so. And then starting in 2001, 2002, 2003, there are a nonstop series of leaks. And a leak is something that's very hard to fix because you don't always know where it's coming from, right? Totally unrelated, I recently had an oil leak in my car, and it was really expensive to fix. So they couldn't figure out where the leak was coming from. So, I mean, generally with leaks, it's hard to pinpoint. A leak is also something that an inspection wouldn't necessarily find, right? In other words, when the prosecutor office moved in, they probably did some research in the building. It's not clear they would have found any evidence of a leak, right? A leak only happens perhaps when it rains really hard, and then once it happens, it keeps happening again and again and again. So this was not something they may have known about going in. There was no warning, perhaps. It started happening. Okay. Let me just make one point on the side. Who's next? That was Victor. Hey, Garrett, you here?
Yes, sir.
Garrett, what are the consequences of having evidence destroyed for a prosecutor's office?
It seems like a lot of cases getting messed up and having to get.
Yeah, why? Why might it mess up cases?
Just because they're losing their arguments or things that they can use to prove certain elements of crimes. Affidavits or like the paper documents are losing like written things, but it could be actual like tangible physical evidence.
Yeah. So I got to tell you, this is a really big deal. And the fact that the prosecutor's office sat by for over a year with all this stuff getting damaged and it moved is really troubling. Thanks, Garrett. Let me just give you a story from when I was clerking. This was a very rare occurrence. So when I was clerking, there was a drug case where a guy was making meth in a basement. I guess people make meth, right? Like Breaking Bad style. And he was busted, and he had all this drugs, and all the tools used to make it. So he had the Pyrex plates and the scales, and like this microwave that was just caked in like cocaine and meth and all the different. I think he made crack as well, like all the different stuff he was making. Crack is basically this sort of crystallized form of cocaine. That's fine. If you don't know, that's actually good. You shouldn't know this, but if you do, now you know. So this guy was sitting in prison for probably more than 2 years waiting a trial. And we get to the trial, and the state detective is on the stand, and the defense attorney is asking questions, saying, how much drugs were there? How did you find them? And all these questions. And then the defense attorney asks a question, and he says, so where are the drugs right now? And I'll never forget, this look on the detective's face just looks pale. And then he's like, where are the drugs? Where's the scale, right? Where are the different tools used to make these narcotics? And there's just this awkward silence. I'm like, okay, what the hell's going on? Because usually in a trial, things are pretty predictable. Everyone follows a script, right? There's not much surprises in that. On TV, there's always surprises in trial. That never happens in reality, right? In reality, things are pretty scripted. You have pre-trial motions for everything, so there's not much surprise. If there's a surprise, something went wrong. And then the detective comes out and says, we don't have the evidence anymore. And the lawyer's like, what do you mean you don't have the evidence anymore? And he says, well, when the case was transferred from the state police to the federal prosecutors, they thought the case was over and all the evidence was destroyed. So all the Pyrex, the microwave, the scales, all the tools, all the primary evidence was destroyed. They had nothing on the guy. So at that point, the assistant U.S. attorney, the federal prosecutor, has this look of like, oh my God. And she says, Judge, we need a break. We need a recess of the court. And then she went and called her boss in Pittsburgh, who was the United States attorney. And like an hour later, they came back to court and said, we're going to dismiss all the charges with prejudice. The guy walked out a free man. He had been sitting in jail for like 2 years waiting a trial, and he walked out a free man. Anyway, I always I mean, this isn't criminal law, but I always give this anecdote at this point saying, this case is so serious that grand jury evidence is being destroyed, right? Even if perhaps the trial's over, people can be retried. Maybe the appellate court reverses the trial for one reason or the other. You might have a retrial 10 years later. And if you don't have the principal evidence, you can't retry the person, right? The evidence might be, I think Garrett mentioned paperwork, right? If paperwork gets wet and moldy, you have to throw it out. It's not scanned. This is old. This is in the 90s, right? You don't have digital versions of documents. If, a murder weapon gets wet and, the fingerprints are gone, or if there's some sort of very sensitive evidence that gets mold on, you have to throw it out and destroy it. What happens to your case? You throw it out. So, I mean, this is such a big deal. And I always wonder when I teach this case, how many defense attorneys actually think to ask, where's the actual evidence? I mean, you wouldn't even think to ask that. But can you imagine if you were a defense lawyer in Indianapolis, you read the story in the paper about the evidence locker being destroyed, and you're like, so where's the evidence? Like, it's covered in mold. We had to throw it out. Okay, good luck, right? So I wonder how many convictions were actually tossed because of this case. Or conversely, how many people were convicted even in the absence of real evidence because they didn't think to ask. So this case just always blows my mind when I teach it. I mean, putting aside property and things like that. Anyway, it's a remarkable case. Any thoughts on this one? Any questions? Yeah, Lisa, go ahead.
I was just thinking how, it was funny to me while I was reading it that, the landlord obviously knows what kind of tenant he has. And I don't understand why he would be so flippant or,
stupid.
It was almost like he didn't even,
yeah.
You have, I don't know. It's just, it's not like he was unaware of what kind of tenant it was.
This is not the tenant you screw around with, right?
Yeah.
This is not like, your guy with no credit who, has no job. This is a freaking prosecutor. It's a criminal. I really, Alyssa, I have the same reaction when I read this case every year. It's like, how dumb can you be, right? This is the prosecutor who can make your life really difficult, who can open up an investigation to whatever they want and just ruin your life. So the plaintiff, and then he sued them for back rent. He should say, okay, go, just he should just let this one go and be like, okay, we're just gonna call it even, right? But this was not a smart move, not a smart move at all. But yeah, I had the exact same reaction. Like, how dumb can this guy be, lying to the prosecutor about the risk of health to their employees? That's a crime, right? If you're going to tell a government agency that your employees are safe, and it turns out there's a risk of disease from this, that's called fraud, right? You're misrepresenting the material part of the lease. That's fraud, right? If your employees get injured and icky, but if they get sick from this, that's damage, right? You can have criminal liability for fraudulent misrepresentation. Anyway, it would cost this district attorney $0 to prosecute this guy for fraud, and anyway, and he sues them. And then one more thing that's always strange about this case: look how long it took. The breach happened in 2003. It didn't get to trial until 2007. So what the hell happened for 4 years just sitting around, right? I don't know the answer. I've often wanted to look into it. I've not been able to actually ever do it. But this case took a real long time. So maybe neither party really wanted to litigate it. I don't know. Yeah, but fair point. All right. So that was Garrett. Hey, David, you here? David? Oh, yeah, you're in the classroom. I'm sorry. I see you waving. Thank you. All right, David, you hear me okay?
Yes, can you hear me?
Okay, loud and clear. Thank you, sir. So I think there are two relevant dates here I want to ask you about. The first date is October of 2002. What happened in October 2002 that's significant for this case?
The landlord sent a letter to the MCPO asking them to move their evidence from potential water damage area, issues that have water issues. So it's kind of like taking assessment of the property.
Yeah, I mean, that's remarkable, David, right? It's basically saying, okay, you signed the lease for this property, but you can't use part of it. I mean, is that something a landlord would usually say?
Because you're supposed to have access access to the entirety of the lease.
That's right. All right. Now, David, the second date I want to give you is January of 2003. Why is that date relevant for our case?
Because whenever NCPO elected to leave the premises because of the recurring issues.
Yeah, it got so bad they said, screw it, we're leaving, right? Okay, very good. Thank you, David. Catherine, I think you're next.
Yes.
So, Catherine, help me out here. What's the difference between actual eviction and constructive eviction?
Actual eviction is when the tenant is deprived of the occupancy of some part of the property. The tenant can withhold rent but not move out. And constructive eviction is the act or omission by the lessor materially deprives the tenant of beneficial use or enjoyment of the property. And in that case, the tenant may elect to abandon the property and avoid further obligations.
Okay, very good. I think you gave me the definitions right from the book. Very good. Let me ask you a follow-up. Was there an actual eviction here in this case?
On the first date of October 2002 was the actual eviction.
Okay, why was there an actual eviction in October?
Because they were deprived of part of the property.
Specifically, what happened in October that deprived them of part of the property?
The landlord sent them the letter to move the evidence that it was stolen, so they weren't able to use that portion of the property.
So is this an actual eviction of the entire property or just part of it?
Part of it.
Okay, good. All right, thank you, Catherine. Right. So actual eviction is when you're actually deprived of at least part or whole of the property. And the part's important, right? You don't have to actually throw out the entire unit, but the landlord tells you can't use X part of it. Say 1,000 square feet, but you can't use 10 of those square feet because it's water damage. That can be an actual eviction. And here it seems the landlord knew there was likely to be future flooding. So he said, yeah, don't keep your stuff there. It's going to get damaged again. It's not, here, let me help you. It's, oh, by the way, yeah, just move your crap, right? Don't keep your stuff there anymore. Again, this is evidence for criminal procedure, for criminal prosecution. This is not like, some random person living in an apartment. This is like, I think Alyssa is well stated. This landlord was an idiot, right? Just really, really tone deaf. So there was a actual eviction, at least of part of the property back in October. Okay, with an actual eviction, you're allowed to withhold rent. With an actual eviction, you're allowed to withhold rent, but you're not required to leave. In other words, if you're actually evicted from part of the apartment, you can just basically offset the rent. Say, you know what? I was paying $1,000 a month and you've just reduced my surface area. I'll give you $900 a month. A court can decide that's reasonable or not, but there's no requirement to actually vacate the premise. Okay. Taylor, are you here?
Yes.
With a constructive eviction, though, is there a requirement to vacate the property?
I think so. With a constructive, that's when you're actually I'm mixing the words. Yes.
How quickly must you actually leave with a constructive eviction? What's the time period?
Just reasonable, so what an objective person would do.
Right. And so, Taylor, why do you think with a constructive eviction, you have to leave within a reasonable period of time? What does that signal that you're actually leaving the property?
In the property, it signals that you're not going to pay rent. Like, you should find someone else to live here because I'm not going to.
Yeah, very good. Leaving means you're serious about it, right? If the conditions were so bad and you stick around, well, that maybe it's not that bad. But if you're saying the conditions are really bad and you actually leave, that's proof. So here's the test, right? With the actual eviction, you can withhold rent, but you don't have to leave. With a constructive eviction, you can withhold rent if you leave within a reasonable period of time. What's reasonable? Who knows? But here, in this case, they left basically right away. So that's probably close to reasonable. All right, so then the case turns of, was there an actual eviction? And was there a constructive eviction? Okay. Sarah, are you here?
Yes, I'm here.
Sarah, according to the court, when was there an actual eviction and when was there a constructive eviction?
The actual eviction was October 2002.
Good.
And then constructive was January 28th, 2003.
Good. And again, why was the October date an actual and why was the January date the constructive?
So October was when they sent the letter, the landlord sent the letter saying don't use a certain part of the building. So it was actual, like a certain, just a portion of it. And then the constructive was when there were just so many leaks. And then that last leak was the final straw. And the landlord made the premises not livable. I guess it's not livable, but like they had to leave because it was so bad.
All right, excellent. Thank you so much. All right, very good. So the court here finds that there was an actual breach. I'm sorry, an actual eviction and an actual. So it was an actual eviction and constructive eviction, right? Once there's an actual constructive eviction under law, the tenant is allowed to withhold rent. Miranda, are you here?
I'm here.
So Miranda, what do we do with this exclusive remedy provision? Is that relevant in this case?
No, it's not relevant here.
Why? That's correct. Why not?
Because with the exclusive remedy provision, it's like the tenant on their own can't withhold rent for any reason. But in this case, it was like actions by the landlord that made the premises like unsuitable for what they were doing.
Okay, very good. We have this provision in the lease called the exclusive remedy, which basically says if there's a dispute between the landlord and the tenant, the tenant has one remedy: sue for damages or an injunction. Right? The landlord cannot the tenant cannot unilaterally terminate the lease. I said it again. The tenant cannot terminate the lease unilaterally. But that's not relevant here. Why? The landlord here breached. And once the landlord evicted, actual constructive, once it was an eviction, the lease became irrelevant, right? The terms of the lease no longer control because the landlord evicted the tenant. In other words, the landlord can't hide behind the lease after screwing up. Once the landlord evicted, the tenant had every obligation and duty to withhold rent. And that's exactly what happened here. The landlord withheld the rent. Sorry, the tenant, I keep inverting in my head, I'm sorry. The tenant withheld the rent after there was a breach, and that was fully justified. Yes, Grayson, go ahead.
So I understand that you have the right to withhold rent, but if you withhold too much rent, the landlord can bring that to court saying, hey, this was not reasonable, we are owed something, if not.
Well, what are we talking about here, right? There were like 4 years left in the lease. And so they withheld the 4 years of the lease. So what would you mean withhold too much rent? Wouldn't you just withhold the remaining amount?
Right, in this instant, yes, but what if there was some sort of like if there was an actual eviction, you're allowed to withhold rent but not required to leave. So like how much rent? Right,
okay, now I see what you're saying, right? So your question is, if you decide to stay, you elect to stay, how much can you offset the rent by? And that's a very hard question because you might decide that, let's say the heat doesn't work, right? And you can't use one of the rooms where there's no heat. You say, well, that room's worth $100 a month. The landlord says, well, that's $50 a month, right? If it goes to court, the court will have to decide what the reasonable amount to withhold is. And the court may decide, no, that's only $50 a month payback. So when you withhold rent, right, you're taking a risk. You're taking a risk that a judge may later disagree with you and determine that you owe more money. And that might be money with interest and penalties as well, because you have to owe it back. So it's always risky when you decide to withhold rent. What also happens sometimes, it's not in your reading for today, but it does happen, is let's say a repair has to be made. Right? Let's say a window cracked and it's the responsibility of the landlord to fix the window, but he's not doing it. So you know what, the tenant says, you know what, it's $100 to fix the window. I'm going to fix it myself. And I'll just take $100 off the rent. The landlord may accept that, or he may say, no, that's not your job, and he may sue for $100. So it's often even withholding funds to pay for repairs may be a risky move, because the court may say that's not your job to make that decision. Make sense, Grayson?
Yes, thank you.
Okay, Rhea, go ahead.
Just to clarify, even if it's actual or constructive eviction, the exclusive remedy provision becomes irrelevant.
Yeah. Either type of eviction, if they actually get evicted, or this constructive eviction with a short turnaround time, a reasonable period, then the lease becomes irrelevant, and there's no further duty to pay rent. Once you're out of the lease, you don't have to pay rent. Good question. Yes, Alyssa, go ahead.
That applies to other kinds of breach that the lessor might do, like even if it's not actual or constructive.
No. The removal of the duty to pay rent is only for eviction, either actual or constructive. Like, let's say the tenant breaches. I'm sorry, the landlord has some sort of trivial breach, where they don't provide a timely painting of the walls. I'm making something up, right? That might be obnoxious, but that's not going to be enough to justify an eviction. In other words, the tenant can't withhold rent for everything. They can only withhold rent if there's an eviction that's either constructive or actual.
What if it's like a material breach? I can't think of an example, but like a.
Well, if it's material in the way I think you're using the word, it might actually be a constructive eviction, right? Let's say that they're.
Yeah.
I mean, if it rises to that level, that means you probably should get out of there. Broken heat is a classic example, right? There's no heat in the winter. At that point, you might consider that a constructive eviction, but you'd have to move out in the middle of the winter, and maybe you have nowhere else to go. So if you stick around and you don't leave, that will undercut your eviction claim.
Right. Okay. Yeah, I got you. Thanks.
But I think if it rises to the level of materiality, right, a material breach, you probably have enough for a constructive eviction. That's probably going to be 1-to-1. Okay. What else? All right. So in this case, the court found that there was an actual eviction and a constructive eviction, and therefore the sole remedy, the exclusive remedy provision was irrelevant. Also, there was no mitigation, right? The landlord here also let the basement sit empty for a full year before taking any action. It's not clear if any other tenants. So even if he had prevailed, I think the damage would have been offset by his failure to mitigate damages. So I think the general rule is if the tenant moves out, it's really the landlord's duty to try and get someone else in there as soon as possible, not to let it sit empty and then sue for it a year later. Yeah, and don't screw with the prosecutor's office. Bad idea. Bad idea. So go ahead.
Nitpicky question, but on the exam, when we cite this case, is it acceptable for us to use MCPO as a instead of the full?
Sure, the Marion County Prosecutor's Office, sure. And Marion County is in Indianapolis, if you want to know where that is, but that's fine. I'll know what you mean.
Okay, thanks.
MCPO. MCPO. Yeah, that's fine. All right, any other questions on the case? there's some notes after the case, not terribly important. There's something called a covenant of quiet enjoyment. And you're going to come across this phrase in Prop1-2, so I wouldn't worry about it too much here. Maybe it'll take over the summer or in the fall, perhaps. But quiet enjoyment doesn't mean, shh, quiet, right? It's not like, no noise. You have noisy neighbors. That's not what this is about. Quiet enjoyment means that you won't be bothered legally, right? You can use your entire property, that there's no interference with the ability to use your property. And generally, most leases will have that sort of covenant in there. There are also some implied warranties. So this is not in your reading, but something called the implied warranty of habitability, which the courts have recognized in the 20th century. And this implied warranty says that the conditions will be in a certain minimal condition that are suitable for living. And this often comes up in these sort of slumlord cases you've seen, where with really, really, really dreadful conditions, whether this implied warranty is violated. Generally, though, the implied warranty doesn't come up very much because most cities have housing codes that require apartments to meet certain conditions, and the building inspectors can hold them accountable. But it's not often very effective there. Hey, Luis, go ahead.
Yeah, so I know you said the covenant of quiet enjoyment will be a covenant in my property too, mostly. But could that be applied to the Keeble case? Because
the whale case or the duck case?
Yeah, because Keeble was trying to use his property lawfully, but Heckering, was firing off the shot, so that noise was, impeding on his property, like the way he could use it. So
I appreciate the reference to the first week of class, but there's no covenant between neighbors, right? A covenant is something that a landlord and tenant reach. There's no privity, so I don't think that would exist.
Oh, okay.
Also, the implied warranty of habitability didn't exist in the 1700s either. But very, very creative. I like where you're thinking. Okay. Let's see what else. That's about all I have for the topic today. What questions do you have in your mind in general, things you want to ask? Yes, Luis, go ahead.
Are you excited for the semester to be over?
Yeah, it's a good question. I wouldn't say excited. I enjoy my job very much. I actually like teaching. So it's always this sort of bittersweet feeling because I work so closely with each and every one of you. And then after next week, I'll probably never see any of you ever again. It's a very strange sentiment, like where you develop sort of this really intimate bond with students, even over Zoom. I still feel like I know you all well enough, and then you just vanish. Maybe you'll take me again in the future, but maybe you won't. So no, I'm not excited. I'm looking forward to a bit of a break. It's been the last year and a half with COVID, which is very, very tough for us all, and we've had to work so much. I mean, I'm teaching now double class. I've never done this before, back to back, and I have another class in the afternoon. It's exhausting. So my Mondays and Wednesdays are plus office hours, basically from 9 till almost 3:30 every Monday and Wednesday, just teaching, and it's hard. It's not easy, but I enjoy it very much. So I will not say I'm sad to see you go. I like you all. You annoy me every now and then, but the balance, I enjoy having you.
Thank you. I appreciate the comments.
I try to be honest. Alex, Michael, go ahead. Then Alex and Lacey.
Yeah, I just had I think you mentioned this previously, but we should be careful about the sample answers, correct? Like there could be some stuff in there that's
They're
wrong.
not perfect.
And so there was a couple things that I disagree with, but one of the first ones that comes on, I just want to ask about. It's one of the sample answers was making an argument for the rule of custom and was saying that it promotes efficiency, and that's not my understanding. My understanding was that the rule of capture promotes efficiency because it's very easy to administer and it's efficient to see who has it at the end of the day.
Mm-hmm.
And the rule of custom.
I mean, a custom can be efficient depending what the custom is, and I don't remember the exact exam you're talking about. I'd have to review it. Again, I've given almost a decade of exams, so I don't remember every question, every sample example. But custom can be efficient. The rule of capture, though, provides certainty. That's for sure. It's a very certain rule because you know who gets it. Really, I think it has to see the question. Maybe we can talk later, but it would vary.
So if you were to compare the rule of capture and the rule for custom,
again, it would depend on what the custom is. Maybe the custom is the rule of capture.
Okay.
Right. It depends what the custom is. So again, having seen it, it'd be hard for me to answer.
Okay.
But thank you though. But don't take the A+ answers as gospel. I mean this sincerely. I've never given 100 in an exam I've ever given. It's never happened. The best papers are in the low to mid 90s. That's usually the A+, and so they get stuff wrong. But
and so even though we can't, if we haven't sent you our answer to one of the exams yet by today, we can still email you and just with specific questions, right?
Yeah. I mean, the way I do it is if you send me a full exam, I can review it with you, but that takes like half an hour, and I can't do that for 75 students. There are not enough hours in the day for that. But if you have specific questions, and I'm going to have a cutoff for the, let me just look at your calendar. What's the day of your exam again? I don't remember. It's the 7th. The 7th.
Yes.
All right. Actually, this might be useful. I have you here, and Michael just deputized you. What is the exam you have immediately before mine? I'm on the 7th I think at 6 o'clock. What's the exam you have right before me?
I think it's maybe Cipro. I'm not sure.
What date is that? Because I can, or anyone,
calendar. Just
shout it out if you know it.
It's contracts on the 3rd, and then we have yours on the 6th.
I thought my exam was the 7th. Is it the 6th?
6th.
6th.
It's the 6th.
Okay. So then you have contracts on the 3rd, and I'm on the 6th. All right, then I'll probably make the cutoff for questions on the 4th. Let's call the 4th at 5 p.m. And I'll tell my other section the same. I thank you for reminding me because I meant to announce that and I forgot. The reason why I do a cutoff for questions, and this is entirely honest, is as you get closer to the exam, the questions become more panicked and freaked out, and they're not very good, right? The questions I get the day of the exam are like, oh my God, I'm panicking. I don't know what to do. And also, I don't have time to respond to them. Sometimes they're really involved questions, and they email me like an hour before the exam, and like, I can't help you with this. Even the questions the night before at like 11 p.m., I can't always get to it in time. So let's just say 5 p.m. on the 4th of May. I think that gives you about a couple days beforehand, and that'll be your cutoff. I know not ideal, but it gives you some time after your other exam to put your stuff together. But really, at that point in the semester, you should be ready. The questions that are asked at this point are really seldom helpful. They're generally people who are freaking out and panicking, and I have to try to calm them down and say, okay, it's okay. You'll be fine. You'll be fine. All right. Michael, did I answer all of your questions? Okay, very good. Okay, I have Alex, then Lacey, and Alyssa. And I'm almost out of time. I'm happy to stick around and keep talking. I'll run the minute poll, but I'm happy to stay for a few more minutes. Okay, Alex, go ahead.
Yeah, just to clarify, you talked about it at the beginning of class, but I just want to make sure none of us screw it up. For the sample answer, you only want us to email our answer if we're wanting to meet with you, correct?
Well, the deadline is basically now. So if you've already done it, you should email it to me. If you haven't, then you missed your chance.
When we complete it on Monday, we don't have to email it to you, just bring it to us.
Yeah. Just show up on Wednesday and I'll go over it. The reason why is having 75 students email me the documents is just not a good use of time because I'm not grading them. So just hold on to it. I'll believe you if you do it. It's not going to grade you on it.
Okay, thank you.
Okay, that's fine. Okay, that's Alyssa. That's Alex. Okay, Alyssa's next.
Would it be possible to have the cutoff be at 7 p.m. on May 4th?
Does that make a huge difference for you?
Kind of, yeah.
God. I usually call it a day at 5. So what's 7?
What do you mean, what is 7?
What's special about 7 rather than 5? If you email me at 7, I won't get till to the next day, maybe even later, and it screws up my schedule. So I'm going to keep it at 5.
Okay.
I just because I usually call the day at 5, and if I don't get to it at 5, I won't get to the next day, and then it's basically defeats the purpose. Okay. Alex, had another question?
No, sorry.
Hands up from before. Okay, what else? All right. Okay, again, yeah, so cutoff will be 5 p.m. And again, I don't like being reasonable, but I have dinner time and kids and things I have to do also. So the 5 p.m. helps me actually answer them in a timely fashion. 7 is a little bit too late. That's dinner time. Because I know if I say 7, they'll get questions at 6:59. That's when all the questions will come in. In the past, I didn't used to give a time. I would get the questions like 11:59 p.m. Like, oh, come on. That's just, give me a break. All right. Because the reason why is invariably some of the questions will be, okay, this is really important. Let me set up a time to talk. And I can't do that if there's like a compressed window. All right. But also, I'm happy to meet with you during the exam period before then. If you want to set up a time, just email me. I'm flexible enough with giving me heads up notice. All right. May the 4th be with you. Very good. Take care, everybody. I will see you in class week from today, Wednesday. And good luck with the sample. Thank you.